If you've been waiting years for your green card and you're terrified that everything is about to change in 2026, you need to stop scrolling right now. Social media is exploding with claims about Congress making game-changing decisions that could either save your future or destroy it overnight. Families are panicking, students are second-guessing their plans, and millions of immigrants are asking the same question. Is my green card application about to become worthless? Before you make any life-changing decisions based on viral posts and rumors, I'm Saqib, and in the next few minutes, I'm going to separate the facts from the fear and show you exactly what's really happening with green card rules, what Congress is actually discussing for 2026, and what you absolutely need to know to protect your immigration future. Let's be very clear about something from the start. Immigration law in the United States does not change overnight. It doesn't change because of a viral tweet, a leaked memo, or a YouTube thumbnail. Real changes to green card rules require one of three things: new legislation passed by both the House and Senate and signed by the President, executive action that follows existing legal authority, or formal rulemaking by agencies like USCIS that goes through months of public comment and legal review. So when you see headlines screaming about game-changing green card rules and Congress decisions for 2026, the first question you should ask is, has anything actually been signed into law yet? And the answer right now, as of today, is no. But that doesn't mean nothing is happening. It means we need to understand exactly what is being proposed, what is being debated, and what could realistically change in the coming months. Let me walk you through what's actually on the table. Congress has been discussing several immigration reform proposals that could significantly impact green card processing, allocation, and eligibility. These discussions have been ongoing for years, but they're gaining renewed attention as we move toward 2026 because of the presidential election cycle, changing political dynamics, and the overwhelming backlash that has come from decades of green card backlogs affecting millions of legal immigrants. The key proposals being discussed fall into several categories, and I want to explain each one clearly so you understand what's real and what's speculation. First, there is ongoing discussion about eliminating or drastically reducing per-country caps for employment-based green cards. Right now, under current law, no single country can receive more than 7% of the total employment-based green cards issued each year. This rule was created decades ago to ensure diversity, but in practice, it has created catastrophic waiting times for highly skilled workers from countries like India and China. We're talking about wait times that can stretch to 50, 60, even 70 years in some categories. Yes, you heard that correctly. There are people who will never receive their green cards under the current system because they will literally age out or pass away before their priority date becomes current. Several bills have been introduced in Congress over the years to eliminate these per-country caps, including the EAGLE Act and variations of the Fairness for High-Skilled Immigrants Act. These bills would allow green cards to be allocated based on the order applications are filed, rather than being artificially limited by country of birth. If such legislation were to pass, it would represent a game-changing shift for hundreds of thousands of people currently stuck in employment-based backlogs. However, and this is critical, none of these bills have been passed into law as of today. They are being discussed, debated, and negotiated, but they are not yet enforceable immigration policy. Second, there are proposals related to recapturing unused green cards from previous years. Due to bureaucratic delays, processing inefficiencies, and the COVID-19 pandemic, tens of thousands of green cards that were authorized by Congress have gone unused. They expired without being issued. Several lawmakers have proposed legislation that would recapture these unused green cards and make them available to people currently waiting in the backlog. This could potentially free up anywhere from 100,000 to several 100,000 additional green cards without requiring any increase in the annual caps. Again, this is a proposal that has strong support among immigrant advocacy groups and has been included in various comprehensive immigration reform discussions, but it has not been enacted into law. Third, there is discussion about modernizing the green card system to address family-based backlogs, particularly for immediate relatives of U.S. citizens and spouses and children of green card holders. Current wait times for family-based green cards can range from a few months to over 20 years, depending on the category and country of origin. Some proposals would increase the annual numerical limits for family-based green cards, eliminate certain preference categories, or create new pathways for long-term undocumented immigrants who have family ties in the United States. These are politically sensitive issues, and any movement on them would require bipartisan cooperation, which has been extremely difficult to achieve in recent years. Fourth, and this is where a lot of the recent attention has focused, there are discussions about potential changes to the asylum system, work authorization rules, and the treatment of certain temporary visa holders that could indirectly affect green card processing. For example, if Congress were to pass legislation that restricts asylum claims or changes the criteria for work permits, it could affect the overall demand on USCIS resources and potentially speed up processing times for other categories, including green card applications. Conversely, if new programs are created that increase the number of people eligible for work authorization or temporary protection, that could strain USCIS capacity even further and potentially slow down green card processing. Now, here's what you need to understand about all of these discussions. The United States Congress operates in cycles, and immigration reform has been a consistently controversial issue for decades. Major comprehensive immigration reform legislation has not been successfully passed since 1986. Since then, we've had smaller pieces of legislation, executive actions, and incremental changes, but no major overhaul. As we move toward 2026, there is increased political pressure from multiple sides. Business groups want more high-skilled immigration and faster green card processing for their employees. Immigrant advocacy groups want protection for undocumented immigrants and family reunification. Some lawmakers want stricter enforcement and reduced overall immigration numbers. These competing priorities make it extremely difficult to pass any legislation, which is why you should be very cautious about assuming that any of these proposed changes will actually happen on any specific timeline. What we do know is this: USCIS processing times for green card applications remain extremely long in most categories. As of the most recent data available, the average processing time for an employment-based I-485 adjustment of status application can range from several months to several years, depending on your priority date, visa category, and USCIS service center. Family-based green card applications face similar delays. USCIS has made some improvements through increased staffing, technology upgrades, and process efficiencies, but the fundamental problem is that demand far exceeds supply. There are statutory annual limits on how many green cards can be issued in each category, and those limits have not been meaningfully increased in decades, even as the U.S. population and economy have grown substantially. So what does all of this mean for you if you are currently in the green card process or planning to apply? Let me give you practical guidance. First, if you already have a pending I-485 application or an approved I-140 petition with a priority date, nothing about these congressional discussions changes your current legal status or your place in line. Your priority date is locked in based on when your application was filed, and any future changes to the law would be applied according to rules established in that new legislation. Typically, when immigration laws change, there are provisions to protect people already in the system, though the specifics vary. Do not abandon your current application or make drastic changes to your life plans based on speculation about what might happen in 2026. Second, if you are considering applying for a green card or are in the early stages of the process, such as labor certification or I-140 filing, you should continue moving forward with your application. Waiting for potential future changes is generally not advisable because you cannot predict when or if those changes will occur, and every day you delay is a day your priority date gets pushed further back. Immigration processing is always based on the date you file, so earlier is almost always better. Third, if you are on a temporary visa such as H-1B, L-1, O-1, F-1, or any other non-immigrant status, and you are hoping to transition to a green card, you need to understand that your temporary status is governed by its own rules and expiration dates. You cannot simply assume that comprehensive immigration reform will happen in time to help you if your visa is about to expire. You must maintain lawful status and follow the existing rules. If your temporary status is expiring and you don't have a clear path to a green card under current law, you need to consult with a licensed immigration attorney immediately to explore all of your options, which might include visa extensions, changing to a different visa category, or in some cases, preparing for the possibility of having to leave the United States. Fourth, be extremely careful about misinformation. Social media platforms, YouTube channels, and even some immigration forums are full of speculation, rumors, and sometimes outright false information about immigration policy changes. People share screenshots of alleged USCIS memos, leaked policy drafts, or insider information that turns out to be completely fabricated. Unless you are reading information directly from official government sources, such as USCIS.gov, the Federal Register, or official congressional legislation published on Congress.gov, you should treat it as unverified. Even news articles and analysis videos, including this one, should be understood as interpretation and education, not as official legal guidance. Fifth, understand that even if Congress does pass significant immigration reform in 2026, it will take time for those changes to be implemented. USCIS would need to update its systems, train staff, publish new forms and instructions, and go through a transition period. Changes would not happen overnight. This is actually good news for people currently in the system because it means you will have time to understand how new rules affect you and to adjust your plans accordingly. Now let's talk about some specific scenarios that people are worried about. One common concern I'm seeing is, will Congress eliminate the green card system entirely and replace it with something else? The answer is no. That is not on the table in any serious legislative proposal. The green card, formerly known as lawful permanent residence, is a foundational part of U.S. immigration law. What is being discussed is how green cards are allocated, how many are available in each category, and how to reduce backlogs, not whether green cards should exist at all. Another concern, will Congress create a points-based system like Canada or Australia? This has been proposed in the past, most notably in bills introduced several years ago, but it is not currently the focus of mainstream immigration reform discussions. A points-based system would evaluate green card applicants based on factors like education, work experience, English language ability, and age, rather than relying primarily on employer sponsorship or family relationships. Some people favor this approach, others oppose it. As of now, it is not moving forward in any active legislation. A third concern, will DACA recipients finally get a pathway to green cards? This is one of the most emotionally charged immigration issues in the United States. There are approximately 600,000 DACA recipients, young people who were brought to the U.S. as children and have lived here for years, often decades. Multiple bills have been introduced to provide DACA recipients with a pathway to lawful permanent residence, but none have passed both chambers of Congress. The political dynamics around DACA are extremely complicated, And while there is significant public support for protecting dreamers, legislative action has been blocked repeatedly. If you are a DACA recipient, you should continue to renew your DACA status on time, follow all program requirements, and stay informed about any legislative developments, but do not base major life decisions on the assumption that a DACA pathway to green cards will definitely happen in 2026. Let me also address something about the future of immigration more broadly. The United States is at a crossroads when it comes to immigration policy. On one hand, the country has significant labor shortages in many industries, an aging population, and a long history of benefiting from immigrant talent and entrepreneurship. On the other hand, there are legitimate concerns about border security, the rule of law, and ensuring that immigration systems are orderly and fair. These tensions play out in every congressional debate about immigration. The reality is that immigration policy in 2026 and beyond will be shaped by which political party controls Congress, who is president, what the economic conditions are, and what the public mood is regarding immigration. No one can predict with certainty what will happen, which is why you must focus on what you can control. Maintaining your lawful status, filing applications correctly and on time, keeping detailed records, and seeking professional legal help when needed. If you are feeling overwhelmed or uncertain about your specific situation, this is the time to consult with a licensed immigration attorney. Not a notario, not a consultant, not a friend who went through the process 10 years ago, but a qualified attorney who is a member of their state bar association and specializes in immigration law. An attorney can review your individual circumstances, explain how current law applies to you, identify potential issues with your case, and help you develop a strategy that protects your rights and maximizes your chances of success. Yes, attorneys cost money, but a single mistake on an immigration application can cost you years of delays, thousands of dollars in reapplication fees, or even deportation. It is an investment in your future. I also want to emphasize the importance of relying on official sources for information about your case. If you have a pending application with USCIS, you can check your case status anytime at uscis.gov using your receipt number. You can sign up for case status updates by email or text message. You can review processing times for your specific form and service center. You can read policy manuals that explain how USCIS adjudicates different types of applications. All of this information is available for free directly from the government. You do not need to rely on rumors or speculation when official information is readily accessible. As we look ahead to 2026 and beyond, here's what I want you to remember. Immigration law is complex. It changes slowly through official channels, and it affects real people's lives in profound ways. Every green card represents a family that can stay together, a career that can flourish, a person who can contribute fully to their community. The delays, uncertainty, and frustration that millions of immigrants experience are real and serious. Advocacy for reform is important, and people should absolutely make their voices heard with their elected representatives. At the same time, you must protect yourself by understanding the system as it exists today, not as you hope it will be tomorrow. The discussions happening in Congress about green card rules and immigration reform for 2026 are significant, and they deserve attention. But until legislation is actually passed and signed into law, nothing has changed. The rules that govern your green card application today are the same rules that were in place last month and last year. Continue following those rules. Stay informed through reliable sources. Seek professional help when needed, and don't let fear or speculation drive your decisions. This is Saqib from Global Immigration Updates, and my goal is to cut through the noise and give you accurate, clear, and honest information about U.S. immigration news, USCIS policy changes, and what it all means for your future. If this video helped you understand what's really happening with green card rules and Congress decisions for 2026, I need you to do 3 things. First, subscribe to this channel and turn on notifications so you never miss critical immigration updates that could affect your case. Second, share this video with anyone you know who is going through the green card process or who might be worried about immigration changes, because accurate information is the best weapon against fear and confusion. And third, leave a comment below telling me what specific immigration topic you want me to cover next, whether it's USCIS processing times, work authorization, visa categories, or anything else related to your immigration journey. Remember, the information I provide here is general education based on current law and publicly available information. It is not personal legal advice for your specific situation. Always consult with a licensed immigration attorney for guidance on your individual case, and always verify information by checking official government sources like USCIS.gov. Thank you for trusting Global Immigration Updates to keep you informed. Stay calm, stay informed, and stay focused on your path to building your American dream the right way.